The case note that today I'm going to discuss is State of Punjab versus Jasbir Singh. It pertains to the scope of preliminary inquiry in section 340 CRPC. Now, the relevant facts pertaining to the case were that a matter was initially decided by Tehsildar Sales Patti in favor of Jasbir Singh pertaining to the transfer of land. Thereafter, the matter went up in appeal before the Chief Sales Commissioner, who decided the matter in favor of the state. While deciding the appeal, Chief Sales Commissioner concluded that Jasbir Singh forged and fabricated the documents. Hence, he directed Subdivisional Magistrate Patti to register the FIR against Jasbir Singh. Honorable High Court of Punjab and Haryana quashed the FIR registered against Jasbir Singh on the ground that the FIR registered against Jasbir Singh did not comply with the mandatory requirements of Section 340 CRPC, which provided for the procedure in cases mentioned in Section 195, particularly because the FIR was filed without any inquiry and without giving any opportunity to him to be heard. In a criminal appeal filed by the state, Honorable Supreme Court considered the factual matrix of the case as well as the law applicable. However, in view of the decisions in the case of Prithvi versus State of Maharashtra, Iqbal Singh Marwaha versus Meenakshi Marwaha, and Amar Singh Nathaji versus Hardik Harshad Bhai Patel, with the subsequent conflicting views taken in the case of Sharad Pawar versus Jagmohan Dalmia, matter was referred before the larger bench for consideration on the points of mandatory preliminary inquiry and an opportunity of hearing to the accused, scope and ambit of such preliminary inquiry. If we talk about the procedural history of the case, the reference has been made by two judges bench of Honorable Supreme Court of India to the larger bench on an appeal filed by the state against the order passed by Honorable Punjab and Haryana High Court in view of the conflicting judgment in the case of Sharad Pawar versus Jagmohan Dalmia. The relevant provision involved under this case was Section 340, which speaks procedure in cases mentioned in Section 195 CRPC. The issues in the case were whether Section 340 of the Code of Criminal Procedure 1973 mandates a preliminary inquiry and an opportunity of hearing to would-be accused before a complaint is made under Section 195 of the Code by a court. What is the scope and ambit of such preliminary inquiry? Now, the legal background and the interpretation of the law. The prerequisite for initiating proceedings under Section 340 CRPC were laid down. That material produced before the court must make out prima facie case for inquiry about alleged offence, and it should be expedient in the interest of justice to hold such inquiry about alleged offence. Mere making of contradictory statement by itself is not sufficient to proceed under Section 340 CRPC, and it must be shown that such statement was made intentionally, and thereafter the court has to form an opinion that it is expedient in the interest of justice to initiate an inquiry. With regard to the scope of preliminary inquiry, the case of Amar Singh Nathaji versus Hardik Harshad Bhai Patel was referred, wherein it was held that in order to form an opinion, the court must prima facie be satisfied that the offence appears to have been committed. For that, the court may hold a preliminary inquiry, though it is not mandatory. If court formed an opinion that offence under Section 340 CRPC stood committed, then it may dispense with preliminary inquiry. If formation of opinion is possible without conducting preliminary inquiry, then such opinion can be formed. Even after forming opinion, the court has to take decision whether it is required to file complaint considering facts and circumstances of the case. Where court feels that it was required to lodge complaint, then it can make the complaint in writing to jurisdictional magistrate. Upon the receipt of complaint, the jurisdictional magistrate has to proceed under Section 343 CRPC, treating the offence as warrant offence. In the case of Prithvi, it was held that the court is not obliged to make a preliminary inquiry or a complaint, but if the court decides to do so, it should make a finding that on facts it is expedient in the interest of justice that the offence should be further probed into. The purpose of preliminary inquiry is not to find whether a person is guilty or not, but is only to decide whether it is expedient in the interest of justice to inquire into the offense. So with regard to whether notice is required to be given to the would-be accused under Section 340 CRPC, it was observed that in the case of Pratish versus State of Maharashtra and others, that in preliminary inquiry under Section 340, subsection 1 by the court in two offences committed in relation to the proceedings in that court or in respect of any document produced or given in evidence, the court is not required to afford opportunity of hearing to the person against whom it might file a complaint before the magistrate initiating prosecution proceedings. Conflicting view was taken in the case of Sharad Pawar versus Jagmohan Dalmia and others. Other case like Iqbal Singh Marwaha and another versus Minakshi Marwaha and another were also discussed. So far the ratio of the case is concerned, the first question was whether Section 340 of the CRPC mandates a preliminary inquiry and an opportunity of hearing to the would-be accused before a complaint is made under Section 195 of the Code. Answering this, it was held by Honorable Supreme Court while relying upon the observation in the Constitutional Bench in the case of Iqbal Singh Marwaha, which was found in line with what was observed in the answer of Pratish case. The answer to the question is negative. Preliminary inquiry is not mandatory in the proceedings under Section 340 CRPC, and there is no question of opportunity of hearing in the scenario of this nature. So far, the scope and ambit of such preliminary inquiry was concerned, reliance was again placed upon the case of Iqbal Singh Marwaha, wherein it was held that before filing of the complaint, the court may hold a preliminary inquiry and record finding to the effect that it is expedient in the interest of justice that inquiry should be made into any of the offences referred to Section 195, subsection 1, subsection B. Further, by relying upon Pratish case, it was also held that the court is not obliged to make a preliminary inquiry or a complaint, but if a court decides to do so, it should make a finding that on facts it is expedient in the interest of justice that the offence should be further probed into. Observing the conflicting views taken in the case of Sharad Pawar, it was observed that the observations made in the said case was in the shape of an order. It was held that the order passed in the said case was on the given factual scenario. Distinguishing between the order and judgment passed by the courts, it was held by Honorable Supreme Court that an order is in the given factual scenario, the judgment lays down the principles of law. The observations made in the case of Sharad Pawar case shows that it came out of the flow of the order than pronouncing any principles of law. So accordingly, it was ruled in the case that the reference was answered accordingly by 3 judges bench of Honorable Supreme Court, and it was ordered that the matter be placed before the regular bench for constitutional merits. That would be all with regard to the presentation of this case note. Till we meet again. Namaskar.